Hey guys, welcome back. Uh, we're going to talk a little bit about rights of the accused today as we talk about civil liberties. But before we do that, I had lots of input on jokes. I guess you guys haven't been liking my jokes, so I got another joke here for you for today, provided by one of your classmates. I already did the Post Malone one. So been sitting at home a lot during this quarantine. Maybe some of you guys have been feeling this a lot too. You've been sitting home a lot, and I've been thinking a lot about going on a diet. You guys know me. I do like to eat, but I've been thinking about going on a diet. But like during this quarantine, I just got too much on my plate right now. Got no time for a diet. Is that laughter I'm hearing? Did you get it? Too much on my plate. Can't go on a diet. Love it. All right. Anyway, let's talk about your civil liberties here. We talked a lot about freedom of speech and things involving freedom of speech. We talked about freedom of religion and things dealing with the Establishment Clause and the Free Exercise Clause. And the next thing that we're going to take a look at today are rights of the accused when you're an accused person. If you've ever been accused of a crime. Hopefully, you've never been accused of a crime, but if you do, you have rights. These are considered parts of your civil liberties. Remember, the criminal justice system in America is limited on what they can do by the Bill of Rights, right? The government can only do so many things to you. A lot of times, failure of the government to follow the rules when they're accusing you of a crime can invalidate a conviction. Courts have to interpret the Bill of Rights when you're thinking about things. They have to follow the rules. Just like if you get in trouble at school, there's rules that we have to follow. Right? We can't just suspend you and kick you out and expel you. Right? There are certain rules that you have to follow. The Bill of Rights kind of lays those things out in America. Like for example, I got the Fourth Amendment here. It talks about unreasonable search and seizures. Right? If the police are going to collect evidence, right? You have certain rights. Okay, when can they collect evidence? Where can they collect evidence at? How are they collecting evidence? What happens to the evidence after they collect it? Right? All of those are part of your Fourth Amendment, and there are certain rules and policies and procedures that have to be followed for the search to be considered valid. And I do like this over here, Miranda rights. Right? We've heard about these before. This cartoon makes me laugh a little bit. You're innocent until proven guilty, no matter what is written on social media and on the internet, right? Do like this cartoon a lot. So let's talk about your rights. Okay, mentioned Fourth Amendment before, search and seizures, right? In order for you to be searched, right, with a policeman, right? If you're out on the street, you get pulled over in order to be searched, right? Policeman's got to have probable cause. And that's what that is. The situation occurring when police have reason to believe that you should be arrested for an illegal act. It doesn't take much for the policeman to have probable cause to search you. A lot of times that standard is very low. But they have to have probable cause to search you. They can't just stop you and immediately begin to search you, search your car. They have to have some type of probable cause. Sometimes searches are considered to be unreasonable. If a search is unreasonable, that means the evidence is obtained in some type of haphazard, some type of random manner. Maybe they didn't have probable cause to search you. If that's the case, then that evidence that's collected cannot be used against you, whether that's evidence is in court or whether that's evidence for an arrest. Right? They cannot use that against you. If it was collected unreasonably without probable cause, or in this case, or in some cases, maybe without a warrant, that evidence can be what they call it excluded, right? Using this exclusionary rule that no matter how incriminating, evidence cannot be used at trial if not obtained constitutionally. That's a big deal, right? They have to follow the rules to collect evidence. Again, as you talk about defendants' rights, that takes you into the Fifth Amendment, right? Which in the Fifth Amendment actually has lots of things in it. It has your due process rights, okay, talking about the government having to follow proper rules and procedures. It involves things such as double jeopardy, right, where you cannot be tried for the same crime twice once your trial is already started. Eminent domain. as part of the Fifth Amendment, an often forgotten part of the Fifth Amendment, where the government can confiscate your property. They have to pay you for it. If it's something for the good of the community, the good of the country. That was used down on the riverfront when they built those stadiums. The government used eminent domain to purchase property from the people that owned it down there to build the two stadiums we have. The Fifth Amendment protects you against the government entrapping you to commit a crime, and it also prevents you from self-incrimination, right? You've often heard sometimes when people are in court, or maybe you've seen on Law and Order, where the people will invoke their Fifth Amendment rights to self-incrimination, right? That's it. You don't have to talk. You don't have to say anything that might incriminate yourself. All that is part of your Fifth Amendment. You do have rights, okay? And that's what we just mentioned here. You do not have to be a witness against yourself in court. You don't ever have to talk to the policeman, actually. If you get pulled over, you don't have to talk to the policeman. If they take you downtown, you don't have to talk to the policeman, right? A lot of times that's unadvisable. You may end up with more problems if you don't simply be courteous and talk to the policeman. But most lawyers would tell you you should never talk to the policeman. You should get a lawyer and have the lawyer talk for you so you do not incriminate yourself. That's part of this court case here. Some of you may have heard of this before. Miranda versus Arizona. He was talked against himself, was kind of incriminated himself for a crime that they weren't even talking to him about. But the guy did incriminate himself without a lawyer present. No one told him that he didn't have to talk. So that evidence that they collected against him was found to be collected illegally. So even though this guy actually committed a crime, because he didn't know that he didn't have to talk, he actually got out of it. That's why they always say they read you your Miranda rights. It's named after this court case there. You have more rights when you commit crimes. We have our Sixth and Seventh Amendment. Sixth Amendment kind of deals with trial by jury, your right to an attorney in a speedy and public trial, and that you have the right to confront your witnesses. The Seventh Amendment also deals with trial by jury, but that's in civil matters. Matters over actually $20, they say. Remember, $20 is a lot of money back when they wrote our Constitution. We don't usually have civil court cases and trials by juries in today's world, and matters are over and around $20. Usually it's a little more than that before you get a civil trial in a civil jury trial. But those are part of your amendment, your Sixth Amendment and Seventh Amendment rights. Remember, this is one of our required court cases, Gideon versus Wainwright. The state must provide lawyers for you in most criminal cases. If you remember our guy Gideon here in the pool hall, they didn't give him a lawyer. They did not give him a lawyer, and because of that, he ended up having his conviction overturned. We have the Eighth Amendment, barring you from cruel and unusual punishment. We see that happen a lot in today's world, especially when it comes to either the death penalty sometimes. Sometimes we see cruel and unusual punishment invoked. We're seeing it invoked a lot today with them releasing nonviolent offenders that are in jails right now, so they don't get the coronavirus. Actually, we're seeing lots of people released. A lot of times we see the cruel and unusual punishment invoked with the death penalty, right? There's a court case that kind of goes along with this. For a long time in our country, the death penalty was illegal. The Supreme Court, in this case, Furman versus Georgia, said, hey, you know what? You're applying the death penalty too much, so we're going to put a stop to it. Death penalty can't be applied at random, and that's what they were doing in some places. So for a short time in our country, there was a moratorium or a stoppage of the death penalty. Although that case has since been reevaluated, and we do have the death penalty again. Please don't commit crimes where the death penalty could be applied. Every state's a little bit different. Texas and Virginia usually execute the most people every year. Hopefully, you can stay away from those. You don't want to do things that get you in trouble like that. But some states don't have the death penalty. 33 states currently, like in our country, have the death penalty. In America, like we talk about the right to privacy a lot. Right to privacy does go with your Fourth Amendment. That unreasonable search and seizure, having privacy rights, that does go with your Fourth Amendment. You have the right to live your life free from the intrusion of government. But this isn't in the Constitution. If you remember when we talked about judicial activism, right? Supreme Court justices over the course of our nation's history have found this to be part of your Fourth Amendment right to privacy. As being, like I said, inferred by the Fourth Amendment. Some people debate it, like do you actually have a right to privacy? Most people would say you have the most privacy when you're in your house. It's when you step out of your house and you start doing things out in public that you, in fact, lose your right to privacy. There's another court case here, Griswold versus Connecticut, talking about a zone of privacy. This is not a required court case. This case deals with birth control when the state of Connecticut actually tried to ban it. But you shouldn't need this for the AP test. And the right to privacy actually leads to Roe versus Wade. We see this a lot. Abortion, many people feel like it's a moral issue, but in our country, it's not. It's a privacy issue, right? It's an issue of privacy, and this is our court case here that dealt with that, Roe versus Wade, that essentially allowed abortions to be legal in this country as a matter of privacy. There are protections for those seeking an abortion, but even the protesters have rights. You are allowed to protest. If you do not like abortions, you can protest at abortion clinics, but there are time and place restrictions of when you can do it, where you can do it at, and all those are to protect people's privacy. All those things where they restrict the rights of protesters, even though you can protest, but they do protect those seeking an abortion because it is in fact a privacy issue. As you're taking a look at this, make sure if you have questions, you shoot me an email, you let me know, and we'll get through it here. And the last thing I just want to mention here, when you talk about civil liberties and democracy, right? That people have the right to express themselves, right? People call these things civil liberties, and the big things with this is that it's tough for governments to define, right? There's that fine line between freedom and order, and people being granted freedoms, all right, but also you got to have a safe place in a safe country. So, like I said, if you have questions, make sure you let me know. And hope you have a great day.